New developments in the murder case of Jimmie J. Lee, the University of Mississippi graduate whose remains were found nearly 3 years after he disappeared. Now this case is taking unexpected turns. A judge has just dropped key charges against the suspect. New ones have been filed, and the man accused of Lee's murder is facing a dramatic legal shift. I'll walk you through the latest details. For Law and Crime News, I'm Kennedi Walker. Law and Crime last reported that Lee's remains had been found after years of unanswered questions, but the case is far from over. Let's start from the beginning. Jimmie J. Lee vanished in July of 2022, sparking a desperate search. He was last seen alive on the morning of July 8th. Surveillance video captured him leaving his apartment complex in Oxford, Mississippi. Then he was gone. For weeks, search efforts turned into nothing. His car was found abandoned at a local towing company, but there was no sign of Jay. His disappearance sent shockwaves through the university and the community. Authorities allege Timothy Herrington lured Jay to his apartment and later killed him. However, without a body and little physical evidence, the case was anything but straightforward. Then on December 3rd, 2024, Herrington headed to trial.
Ladies and gentlemen, you will see how the police traced Jay to that apartment. You will see that when Jay gets there, he lets Timothy know he's there. But right before Jay gets to his apartment, when he's headed over, right before he gets there, just a mere minutes, Timothy searches how long does it take to strangle someone. The evidence will further show that Jay never left that apartment on his own.
And on December 11th, the trial ended in a mistrial. After 3 attempts, the jury couldn't reach a unanimous verdict, forcing prosecutors to regroup.
I'm going to declare a mistrial.
Nearly 3 years after Jay went missing and just days after a mistrial was declared in Herrington's case, investigators made a shocking discovery. Jay's remains were found. And get this, according to the state, the location of Lee's body was approximately 19 minutes away from Herrington's family home in Grenada, Mississippi. Now, the man accused of killing him is facing new legal challenges, while one of the charges against him was just dismissed. Days after Lee's remains were found, Herrington was recharged with capital murder plus tampering with evidence, something he was not charged with the first go-round. According to the affidavit obtained by Fox 13, Herrington allegedly intentionally destroyed, mutilated, removed, and/or altered Lee's body to avoid being caught. The charge carries a sentence of up to 10 years in prison and/or up to a $3,000 fine. Herrington has maintained his innocence but was arrested once again. He pleaded not guilty. This time, he was denied bail. Since December of 2022, Herrington has been out on a $250,000 bond. But prosecutors argued that the discovery of Lee's body changed the circumstances. His attorney fought to have the tampering charge dismissed. They claimed the new charge no longer met the statute of limitations, arguing that since no indictment or arrest warrant for the tampering charge was filed before July of 2024, the prosecution was time-barred. Judge Kelly Luther agreed. He said in this ruling obtained by WJTV that prosecution for the tampering charge was commenced outside of the 2-year statute of limitations and is therefore time-barred. This was a victory for the defense, but they still have an uphill battle. Herrington remains behind bars for the capital murder charge. In Mississippi, a capital murder charge, which means the intentional killing of another with aggravating circumstances, carries the potential for life imprisonment without parole or the death penalty. The state said they will not be seeking the death penalty. Prosecutors are charging Herrington with capital murder because they allege Herrington killed Lee to avoid being exposed as gay. Lee was known for his active role in Oxford's LGBTQ+ community and his involvement as a local drag queen. Herrington, however, was not known to be open about his sexuality. His dad testified during Lee's original trial that he didn't know his son was interested in men until he was arrested.
Were you aware that Timothy had an interest in men?
No.
Today, are you aware that he has an interest in men?
By the proceedings, yes.
And so, back in 2022, were you aware that he had an interest in men?
other than the reports that came out.
So after the reports came out is when you discovered that?
Yes.
So he was not open with you about that?
No.
Is that something that your church approves of?
Not necessarily the church approves of. I think that with that, people have their own opinions.
Lee's family has told local media they are happy that justice is closer to being served. And here to discuss this with me is Marian Bracha, who's a law professor at Temple University and teaches evidence. Marian, thank you for joining me today.
Of course, thanks for having me.
So let's just dive right in. The tampering charge was dropped because it was commenced outside of the 2-year statute of limitations. For those that don't know, what does it mean to be time barred?
Well, for most criminal charges, there is a period of time, a length of time that the government would have to bring those charges. Sometimes it's 2 years, sometimes it's 5 years, depending on the gradation of the charge and depending on the severity. Apparently, in this jurisdiction, for this tampering with evidence charge, the statute of limitations was 2 years because the alleged activity happened in 2022 and it wasn't charged until more than 2 years after that.
Does the same time bar apply to all charges in all jurisdictions?
No, definitely not. So most of our criminal law as we know it is based on state law. And so state laws do vary from state to state, as do the statutes of limitations that apply to each of those criminal offenses. A lot of them are similar. There are certainly similarities from jurisdiction to jurisdiction, but they are not uniform across the states. The federal system, of course, is uniform, but under state law, you will see different statutes of limitations for different charges.
Why isn't there a time bar to the homicide charge?
Well, historically, we consider homicide to be the most egregious offense and the most serious criminal charge that could be levied against a criminal defendant. So there's no time bar on a homicide charge across the board. So in any state that I know of, there is no statute of limitations to bring a homicide charge. And the reason for that is a societal one and a philosophical one. We have decided as a nation, as a society, that we do not want to time bar the prosecution of homicide charges. We as a people have decided that that is one charge in particular that we don't think anyone should ever be able to evade prosecution for. And so while all of the same constitutional rights would apply, rights against unlawful search and seizure, rights against self-incrimination, certainly a right to counsel, there is no time bar to at least the government pursuing a homicide charge against a particular defendant.
Can you explain why the charge added to the second why was the charge added to the second indictment if he wasn't tried on it in the first trial?
So I think the theory behind that is that after the first trial is when the decedent's remains were found. So after the body was recovered, after there was a crime scene recovered, it was the theory of the charging authority, the police, the investigators, eventually the prosecution, that in order to evade prosecution, in order to cover up one's tracks, so to speak, allegedly, of course, the defendant tried to hide the body, secrete the body, hide any evidence of his wrongdoing. And so that would have formed the basis for the tampering charge once the body had been found. My information is that the defendant was tried on the first trial previously before the body had been recovered. And so without evidence of how it had been secreted, hidden, made to be not found or unfindable, that charge wouldn't have applied the first time around.
Is the dismissal of the tampering charge fatal to the homicide prosecution?
No, absolutely not, because there are completely different elements that need to be proven for the homicide charge. For first-degree murder, we're looking at an intentional, premeditated killing of another human being. Those are completely separate elements to what would have had to be proven by the prosecution on the tampering with evidence charge. So there is no bar whatsoever to proceeding with the homicide charge just because the tampering charge is no longer on the complaint.
Can prosecutors still mention the facts that underlay the tampering charge, or because it was thrown out, they're not able to?
I think they can. I think it will, of course, be judge dependent, and it will likely come down to the argument of the attorneys at trial, or more likely in a pretrial motion. But really, the evidence and the facts that underlie the tampering with evidence charge kind of tell the story of the case. A lot of times we talk about evidence that shows a defendant's consciousness of guilt or indicia of consciousness of guilt, meaning that they knew that they had done something wrong. And so that is part of the evidence to show state of mind, or mens rea, that there is a guilty mind. So the prosecution, I would venture, will want to introduce evidence of how the body was disposed of, how the body was secreted or hidden, because again, I would think that the prosecution's theory would be that this is all part of the telling of the crime, that the defendant had this consciousness of guilt, had this consciousness of wrongdoing, and so wanted to take steps to cover up his tracks, so to speak. And so that is all part of the story of the case. Now, will the defense object to that and say, if you're outside the time, date, and place of the actual homicide that has been charged, those other facts are ancillary, they're irrelevant to this case? I would anticipate that the defense would argue that. And then, of course, it'll be up to a judge to determine if there is a sufficient nexus between how the body was hidden and then later discovered by investigators, and what, if anything, that proves as to the defendant's state of mind.
Well, let's talk more about that. How would this evidence factor into the prosecutor's theory of the case? I guess it just depends on what type of evidence that they have.
It does, and I think that something that we've talked about before is something that's really difficult to prove in any court of law, in any criminal court, which is state of mind, which is getting inside an actor's mind, their decision making, and being able to prove to an objective fact finder what they were thinking, what their motivations were, what their intentions were. That's something really difficult. And often if we have witnesses who are trying to testify as to what someone was thinking or feeling or seeing or hearing, the objection would be to speculation. But on this other end of the spectrum, the prosecutors have to prove one of the elements of a homicide charge, which is the specific intent to take a life. And so going about the business, even after the fact, of hiding evidence, of covering up one's tracks, it does go to show that one is mindful of the wrongdoing that was committed. And so that does factor in my opinion, into the intent element, into the mens rea, or the guilty mind proof that needs to be shown.
What types of forensic evidence are most commonly used in cases like this, where there is no direct eyewitness testimony?
Sure. Well, forensic evidence is really the term that we apply to any kind of evidence that's used in a criminal investigation that is based on the scientific method. So I think that our TV shows have given us something of a skewed view of what forensic evidence is. We have these images of these dark, high-tech laboratories with white coats, and it's not always like that. I'm sure that there are some crime labs that look like that in places in the United States. But really what we're talking about is the scientific method applied to a criminal investigation. So forensic evidence could be evidence from the body itself. It could be DNA testing. It could be trace evidence. It could be environmental testing of the area where the body was recovered. It could also be digital or electronic forensic evidence, things like cell phone records or cell phone tower pings, or video evidence, surveillance footage, even things like GPS records or easy pass records to show movement of vehicles on the highways. So it's really any showing of a process to develop the evidence in a particular investigation. And really, I don't think we have exhausted the available means or sources of forensic evidence yet, because they are developing every day.
So will there be challenges because of this with the prosecution? If so, what challenges will they face when attempting to secure a conviction?
Well, I think you've already touched on it, which is the fact that, as far as I know from the previous case and the discovery that's available in this case, there are no eyewitnesses or anyone claiming to be an eyewitness to this murder. So there will need to be a showing entirely based on circumstantial evidence to all of the elements of the homicide charge here. Is that problematic for the prosecution? No, because any element of any crime charge can be proved entirely by circumstantial evidence. The law does not give a preference to circumstantial or direct evidence. If the jury accepts as true the circumstantial evidence that is presented to it, and if the jury applies weight to the evidence, even the circumstantial evidence that it hears, then that could be sufficient to sustain the prosecution's burden to prove this charge beyond a reasonable doubt. Is there a preference for eyewitness testimony? I suppose sometimes, but even eyewitness testimony has serious issues and detractors to its weight and reliability. So oftentimes, evidence that is produced, even circumstantially through the scientific method, might prove to be weightier in a jury's eyes than an eyewitness whose memory might be fuzzy, or whose vantage point might have been challenged, or who might have personal biases or motivations or interests in the outcome of the case. So humans are fallible. Science is as well, but it really depends on the method that is applied to developing that evidence and how it's presented in court.
Now, Marion, you are a former prosecutor, so you've been a part of a lot of trials, witnessed a lot of trials. This first trial ended in a mistrial. What is the possibility of that happening again?
Well, there's really no way to put a probability or a possibility on that. Is it possible? It's always possible that a jury again will not be able to reach a verdict, a unanimous verdict. So I can't really speculate as to the likelihood of that. It is always a possibility going into a jury, but there are as many different ways to try a case and as many different ways to pick a jury as there are people on this planet. So there's really no telling how the evidence will be presented this time around, how the evidence will be received by this different panel of jurors this time around. And so we really do have to wait and see how the jury considers the evidence.
Should we expect the prosecution to sort of change their strategy, or this time just do it all over again because at least they do have a body or, remains?
So I'm not sure that they would change their strategy. I think the fact that they do have the remains of the decedent now certainly changes the weight of the evidence. It is hard to make a finding that there was an intentional taking of a human life when there is no proof of a life and being that ceased to be. So I think the fact that there have been remains recovered, and I think what will be most important for the prosecution this time around is linking that crime scene, that location where the body was recovered, to the defendant, or to show his access to it, to show what steps he took to access that area and dispose of the body. I think that is probably the most telling piece of evidence this time around. But I would anticipate that the evidence that was presented in the first trial is likely going to be presented again, with the addition of the investigation that led to the discovery of the decedent.
If a mistrial does happen again, what exactly would that mean?
Well, it means that a second panel of jurors has again failed to reach a unanimous verdict. Is that a bar to a third prosecution? It's not. Prosecution could proceed with yet another trial if in the event a second mistrial was declared. I think at some point the prosecuting authority has to make a decision as to the likelihood of a conviction, as to the expenditure of resources, of investigators, of witnesses' time, of resources within the prosecutor's office itself to have an assigned attorney and investigator on the case being occupied for a trial preparation process, and then certainly the trial process. So I think there are a lot of policy decisions that go into whether or not a case is tried after a second mistrial. But is there a legal bar to it? There's not. The case could be tried again, a third, even subsequent times, until there is a verdict. Of course, once there is a verdict, then jeopardy would have attached. But there wouldn't be a bar, even if there is a second mistrial.
Now, Jay Lee's body was found, but it's been nearly 3 years. How do law enforcement officials go about collecting and analyzing evidence from a crime scene that has been disturbed or altered over time?
Right. Well, I think that recognition, the fact that there have been environmental changes, the fact that there have been certain climate changes, changes to the body itself in its decomposition process, those factors all have to be considered in, again, applying the scientific method and in developing testimony about the manner and cause of death and the condition of the body. There is certain forensic evidence that is certainly still available, even after all of this time. DNA evidence would be available. Certain toxicology evidence might be available from the remains. Certain environmental factors, depending on how well the scene was preserved, things like shoe marks or tire tread marks, certain vehicle evidence, vehicular evidence, other things like, we mentioned DNA, but other things like threads or fibers or certain clothing residue, things like that. Gunshot residue may even be available this many years after the fact. It really depends on the scene, on what environmental factors would have affected that scene in the past 3 years, since ostensibly the body was placed there. And all of that would be taken into consideration in the scientific process to develop that testimony.
I guess it just gets a little confusing when it's been, so many years and just the elements of outside and things like that. Like, what type of evidence is usually collected long after the crime took place? Like, is it really that easy to be able to find those specific things years after? Do we have that technology?
Oh, I don't think it's easy, even if you're doing that analysis the same day of a crime when it's committed. And I certainly don't mean to make light of it, but it is an exceedingly challenging endeavor and a very advanced field of science and of method. And my hats off to the investigators and the forensic experts who dedicate their lives to this craft. So no, it is certainly not easy, but is there technology and are there precedents for the discovery of this evidence even years later based on an outdoor crime scene where certain physical evidence, things like the things that we talked about, like DNA, like trace evidence, like toxicology evidence, all of those things may be preserved even in an outdoor scene many years later. And remember, there's also the digital evidence, the forensic surveillance evidence that we talked about that would be digitally or electronically preserved that may still be available to investigators if that factors into this investigation as well.
Now, you mentioned a little bit ago the pathologist. What role do forensic pathologists and medical examiners play in cases where the victim's remains are found years later, like Jay Lee?
Right. So they are integral to the investigation, and they would likely be called to testify at the trial. And they are the investigators and the scientists who would determine not only the cause but the manner of death. So if the cause of death was a homicide, if it was an intentional killing, then they would be the ones to examine the body, examine the remains, and be able to determine, if they can, to a reasonable degree of scientific certainty, the manner of death, how it was that life ended, how it was that what was perpetrated against that human life that caused it to cease in being. So they are integral to not only the investigation, to determining cause and manner of death, but also certainly to testifying and to establishing the prosecution's burden of proof once this proceeds to trial.
How does the forensic examination of a suspect's property, like maybe their home or their vehicle, potentially tie them to the crime in a case like this?
Oh, it absolutely can, because if we're talking about DNA evidence, we're not just talking about DNA evidence of the decedent. We might be also talking about the DNA evidence of the perpetrator, or in certain instances of third or other participants or contributors to DNA evidence, which might be helpful to the defense. There is other evidence, like we mentioned, tire track evidence or footprint evidence or certain trace evidence. If those things are also connected to the perpetrator, wherever he lives or wherever his belongings are found or recovered or searched, those things can also link him not only to the crime but to the decedent and to the crime scene. But again, there is always a possibility that that there will be a lack of evidence, that the defense might want to capitalize on the fact that you did this thorough investigation over several years and were not able to find DNA evidence matching my client to the crime scene. You were not able to find garments or items of clothing or hats or outerwear in my client, in the defendant's home or abode, or wherever he frequented, that would match trace evidence or fibers that were found at the scene. Now that's a very powerful piece of evidence for the defense. If they do match, or in scientific terms, if they are consistent, then that might be a stronger point for the prosecution. So it really works both ways. It just really depends on what scientific investigators can reveal.
Great. Thank you so much, Marion, for coming on today. This is something that I know we will be following closely.
Thank you, Kennedi.
Herrington's retrial has been scheduled for October 13th, 2025. Reporting for Law and Crime, I'm Kennedi Walker.